That's what we call the fourth department. Hear you. All take that.
Thank you. Please be seated. The only case on for argument today is case 537.1 Burns versus Andrea Stewart Cousins. Counsel? Please. Yep.
Before I begin,
let's wait until everybody gets settled.
Sorry.
Counsel, if that's all right. Very good. Proceed, counsel.
Well, before I begin, I request that I be given 15 minutes for argument. Currently, I have 10 minutes. The respondents collectively have 20.
You're asking for rebuttal?
No, I'm not asking for rebuttal. I'm asking for 15 minutes for my opening time.
Oh, that's fine. Yes, you can have 15 minutes.
Okay. Thank you, Your Honor.
Proceed, counsel.
May it please the court, Dustin Brockner on behalf of appellants. While this action suffers multiple procedural defects, including that it's untimely and plaintiffs lack standing, I'll start by explaining why the action is meritless. The constitutional amendment process does not grind to a halt merely because, for whatever reason, the AG failed.
Counsel, let me ask you this. Let's change up the argument a little bit here, and let's go with the timeliness argument, because if that gets resolved in your favor, that's game, set, and match, right?
Correct.
Okay. So address the timeliness issue up front, if you wouldn't mind.
Yes, Your Honor. This, assuming this case is justiciable, it is barred by the Article 78 4-month statute of limitations. This is a narrow circumstance in which an Article 78 could be available. This is a procedural challenge to a resolution, and where the alleged procedure is not internal but set forth in the Constitution. And as the Court of Appeals has held, and as this court has recognized most recently in matter of Cobbs Hill, where the challenge is not to the substance of an enactment, but rather the procedures that were followed, that is cognizable under Article 78.
Is that a contested issue in this case as to whether it's procedural or substantive?
No, it is not, Your Honor. Supreme Court said directly they're not challenging the substance of the concurrent resolution, and nowhere even says what that substance is. So this is procedural. It is alleging that the steps that were followed leading to the enactment were not in compliance with the Constitution. So that is, in these narrow circumstances, a quintessential procedural challenge that's cognizable in Article 78.
And that makes it a 4-month statute of limitations, which starts to run from when?
The date of July 1st, 2022.
And this action wasn't commenced for some 14 months as opposed to 4 months?
That's correct, Your Honor. Over 15 months, October 2023. That's exactly right, Your Honor.
July 1, 2022, because that's the time that the first concurrent resolution was adopted.
Yes, that's when the alleged procedural violation occurred.
Now let's stick with that for a second, because as I read Save the Pine Bush and Skolnick, we are to examine the substance of the action to identify the relationship out of which the claim arises and the relief sought. The relief sought here on this appeal or in this action is to invalidate the concurrent resolution. If it were an Article 78, as you say it should have been, what would the relief have been that was appropriate from your perspective under Article 78?
Yeah, it would be that the determination to adopt the resolution was invalid. That is the challenge in matter of Cobbs Hill that this court applied as to.
Would that be prohibition, mandamus, or certiorari? You know where I'm going to go.
Yes, of course. It would be mandamus to review, Your Honor, that it's a determination made in lawful procedure is the closest fit. And also, I'd like to point out they're not challenging the constitutionality of legislation. They're challenging a concurrent resolution. So this is different from all the cases they cite for that additional reason. And in fact, the Court of Appeals in Press versus County Monroe drew that distinction in recognizing Article 78 was available to challenge the constitutionality of a resolution, emphasizing this is a resolution, it is not a statutory provision, it is not a local law.
Did you make that argument in your brief?
Yes, Your Honor.
Okay, I'll look for it again. Hoyman, it just stands out for me, so I may be the only one really focusing on it, but Hoyman from the Court of Appeals, all right? No one's really arguing this, but do we have to distinguish between the type of procedural impediment that's involved here? I think the second department, you're going to know what I'm talking about, talks about, bear with me, an action of substance or something like that. You may recall the language from the second department that talked about, was it a departure of substance? That's the language that the second department uses. So should we be focusing on whether or not this letter or whatever it is from the AG, the opinion, is a departure of substance from procedure? Is that even involved here? Because below, you folks went back and forth on the effect of Hoyman. You seem to say, hey, the plaintiffs are saying Hoyman invalidates Atkins, Islandia, our Shiner case theoretically, and you say, no, that's not what Hoyman stands for. So how does Hoyman fit here? And the reason I'm confused about it is you didn't even cite Hoyman in your brief, and yet it was the subject of debate below. So how does it fit in here?
We did it, they addressed it, we addressed it in our reply brief, Your Honor, because we do not think it applies, so there's no need to address it up front, because that's a very different case. The Court of Appeals even calls it unique circumstances, and it is a one-page opinion, pure curiam opinion, that plaintiffs say stands for this broad proposition, no statute of limitations applies. Not 4 months, not 6 years. If you're saying an enactment of a local legislature or state legislature is invalid, then bring the lawsuit whenever. That is what they think Hoyman stands for.
And they don't even argue whether or not there's a distinction among procedural defects, that is between departure of substance and departure not of substance. That's not even before us as I read the briefs. Am I close?
That's exactly right, Your Honor, that maybe in a different case there could be a dispute whether it's procedural or substantive. There is no dispute here. This is Supreme Court's opinion. It's crystal clear. This is a procedural challenge. This is about the steps leading up to the enactment. Hoyman was a very different case. We addressed it in our reply brief. In that case, it involves a challenge to a law that a subsequent action had to be taken, that a local law did not take in effect because there was still a remaining step, a referendum. Whereas in this case, they're saying a challenge is a resolution is void ab initio, that no matter what happens in the future, it is invalid, and for that reason, it's just a very different case. In that case, it was just a law never took effect because there was a last step that never occurred. Here,
Hoyman effectively eliminated the right to vote altogether.
And that's exactly right, Your Honor. The court did was aware of sort of the nature of the harm, which is very much unlike the nature of the alleged harm here, which is a purely advisory opinion that no one in the legislature needs to consider. In fact, nothing in the Constitution requires this opinion to even be distributed to any individual legislature.
One last thing from me on Hoyman anyways. If Hoyman stands for the proposition that the plaintiffs argued below, and I don't see them argument here, but if it stands for the proposition that for what they argued below, that is, it effectively negated Atkins, which was a permissive referendum. Islandia, I think, was a permissive referendum in part. So if Hoyman is that big, you would have think, first of all, Hoyman, the Court of Appeals would have cited to save the Pine Bush and Skolnick, which they didn't. But the point I'm trying to make is if Hoyman is that broad of an application, then there's a whole lot of appellate division cases that have been negated. Am I close on that?
That's correct. It would be quite destabilizing, and you would not, and the Court of Appeals calls this unique circumstances. Spells out quite clearly, and it's just very brief, that if a later act needs to happen, and it doesn't happen, the right to vote, that in those unique circumstances, no statute of limitation applies. That's far cry from here, which is a quintessential procedural challenge. A certain procedure had to be followed at the time of the enactment, and allegedly was not. If I may turn to plaintiffs also lack standing, but I just want to talk about why as to the merits, constitutional text, settled practice and purpose make clear the timing of the AG's purely advisory opinion has no bearing on an amendment's validity. I like the last sentence of Article 19, Section 1, the no invalidation clause. It clarifies timing does not matter. A proposed amendment cannot be invalidated based on a failure by the AG to render opinion at the time the legislature votes, regardless of the reason for that failure. The Supreme Court's reading of that last sentence is overly restrictive. It reads that clause to cover only one circumstance, when the AG fails in her duty to give an opinion within 20 days. That reading makes much of the last sentence, a no invalidation clause, surplusage. That clause has two parts that covers any failure, both failures of render opinion within 20 days and any failure more broadly, meaning that an opinion hasn't occurred. There's been a non-occurrence of the opinion at the time the legislature votes. I'd also like to talk to legislative practice. Court of Appeals in Brown held that when addressing a claim under Article 19, Section 1, which is what we have here, legislative practice can be decisive if it's reasonable. And that principle applies. The legislature has long used this procedure that plaintiffs challenge here. It's led to at least nine constitutional amendments. And this practice is at least reasonable in light of the text for the reasons I've been discussing.
Well, Counselor, factually here, the legislature just didn't wait for the attorney. It wasn't the Attorney General failed to do anything. It was the legislature failed to give the Attorney General an opportunity to give their opinion. And it's a constitutional requirement, isn't it?
No, it's not a constitutional requirement. At least it is not the receipt of the opinion is not a essential precondition that serves as grounds to invalidate the democratic deliberation on a constitutional amendment. But as to your point, you're focusing on the word failure. And plaintiffs and Supreme Court have a very narrow definition of failure. Failure means breach of the duty. And failure could include that circumstance, but it's not so limited. And in fact, the clause just says, it doesn't say failure of the Attorney General to render an opinion within 20 days. It does not say that. It doesn't say breach. It just says failure. It has two parts. Failure of an Attorney General to render an opinion and failure to timely do so. That second circumstance includes when the AG has not given an opinion within 20 days, but that first circumstance is not so limited. Together, failure just means, at least the best reading and at least a reasonable one, is failure includes just there's a non-occurrence of an opinion at the time the vote happens. And at a minimum, this clause would be ambiguous, and not only do we have practice, which can be decisive, we also have the presumption of constitutionality. That applies, Frank versus State, applies to challenges under Article 19, Section 1, like what we have here. And further, plaintiffs cite nothing to suggest that the AG was ever intended to be a essential precondition that at the Constitutional Convention in 1938, no one's saying we are imposing a strict precondition to legislative action. They're just acknowledging that it would be purely advisory. And the last sentence just clarifies that limited purpose solely to advise the legislature if it so chooses to consider that opinion, but it's not an essential precondition. And in this respect, it stands in stark contrast to the other parts of the Constitution, which show that when the Constitution intends to pose an essential precondition, it says so clearly and it says so directly. Article 3, Section 14, that deals with the passage of bills. So we're dealing with passage of amendments. This deals with passage of bills, and it's crystal clear. No bill shall be passed unless it has been on the desk of the legislatures for 3 days, or unless the governor issues a message of necessity. Similarly, the home rule provision, it's Article 9, Section 2B, legislature has power to do an enactment only if a home rule message is provided. So that is clear that when there's an essential precondition imposed, the Constitution is not ambiguous. It's clear about that. It uses words unless, unless or only. And here we have nothing like that at all. Instead, we have an ambiguously phrased second sentence, and to the extent there's any doubt, the last sentence, the no invalidation clause, just clarifies this is not an essential precondition. And lastly, I'd like to talk about standing. That just fails for two reasons. First, contrary to what Supreme Court held, there's no impenetrable barrier to review. Even under Supreme Court's theory, there's a class of plaintiffs who could, in theory, allege direct and personal injury. That's legislators. but there's no legislator standing here. First, plaintiff waived legislator standing, and Supreme Court erred in granting relief on a theory that plaintiff had waived. We below argued no legislator standing. Plaintiffs failed to dispute that. We pointed out they failed to dispute it, so they waived it. That's page 361. And in response to us arguing waiver, they don't dispute that either. That's page 389, 390 of the record. So that issue is off the table. There is no legislator standing, and at a minimum, plaintiff never alleges any facts to suggest how she was injured by the procedure here. This is an Attorney General advisory opinion that this amendment would have no effect on the Constitution's other provisions. Plaintiff never alleges she would have ever considered this, that this could have been at all material to her. So in these circumstances, even accepting legislative standing could be viable. Does not apply here. And unless the court has any questions, we ask that
No questions, counsel.
you reverse and declare the concurrent resolutions valid. Thank you.
Thank you, counsel. Counsel?
Good morning, Your Honors. May it please the court. My name is Lisa Perillo with Perillo Hill. I represent the minority defendants, that is Robert Ort, the minority leader of the Senate, and William Barkley, the minority leader of the Assembly. The minority defendants briefed below, and their briefs were part of the determination on the motion. Our briefs did not address the procedural issues, so the timing, the standing issues, which were directly predominantly at the plaintiffs. Our briefs focused more on the merits, the interpretation of the language of Article 19, Section 1. As such, I'd like to address some points that the appellant brought up just now. Appellant's readings of the last sentence of the of Section 1 of Article 19 renders the prior two sentences superfluous and nugatory. Those previous sentences impose a mandatory duty to refer the proposed amendment to the Attorney General and a mandatory duty on the Attorney General to act in issuing an advisory opinion within 20 days. And only then, upon receiving that Attorney General's opinion, may the legislature proceed to act on that proposed amendment.
No, counsel's point was it didn't say only then. It didn't use that kind of language when you take the next step.
I submit to you that the upon receiving language is the same exact thing as only then, because it means that you may not act until you have it in hand when you receive it. What you do with it when you receive it, that's up to you, but you have to wait to get it, or you wait until the 20-day period ends. That's the time period that the Attorney General has within which to issue this opinion, and if they don't issue this opinion within that 20 days, they are not able, by that failure of completion of the duty, to stymie the legislature from proceeding. And so the last sentence provides a cure for that situation where the Attorney General has not acted within the 20 days, and the Attorney General has not indicated in any way that they are going to refuse to act. So there is a condition precedent in this provision that requires that period at least to elapse or the receipt of the opinion before the legislature can vote. That's clear, it's unambiguous, and it's manifest in the language of the Constitution. So you can't depart from that. I also submit to you that that makes legislative practice really irrelevant here, because that comes into play, as the case law supports, only when there is ambiguity, when there's discretion, when there's been authority to act in a certain way as opposed to another, or when there's been a limited direction, like in Brown, I hope I'm getting that right, where you had to put in the journal the substance of the amendment. Was it enough to write in the title? Did you have to put the whole thing in? That was left up to the discretion of the legislature because it wasn't in the language of the statute. Here, the process is sequential. It tells you when you have to do what, and it wasn't followed here. That perforce makes this a nullity. It has to, because there's a constitutional regimen that wasn't followed. And I think, because of the focus of your prior questions and my limited time, if you have any questions for me, I'm happy to answer them.
No further questions, Counsel?
Thank you.
Hi, good morning. Christian Brown for the respondents. I guess I'll start by addressing the jurisdictional issue, the Article 78 issue. So we've been throwing around the term procedural. Well, in a way, this is procedural, but sometimes procedure is substance, and sometimes procedure is jurisdiction. This is a jurisdictional question. The question here is, does the legislature have the authority, the constitutional power to vote before it receives the amendment? If the answer to that is no, then clearly this has to be challenged by a declaratory action. Any local board would be challenged by declaratory action if its action, the question is not whether, say, a zoning board granted a variance and was the variance arbitrary, granted in an arbitrary and capricious manner. That's in Article 78. But if a zoning board, for example, acts outside its statutory jurisdiction, say it rules on a matter that wasn't before it on appellate jurisdiction, that is always subject to challenge. It's subject to challenge by a declaratory action. It's void ab initio because the board or the body is acting beyond the scope of its jurisdiction.
Understood in terms of your argument, but in your brief, you cite Hoeyman for the proposition that an invalid legislative act cannot become operative through the mere passage of time. Clearly the case says that.
Correct.
But that assumes, doesn't it, that the law is invalid and that but your brief doesn't talk about the basis of the invalidity. And what I'm driving at, as I did with the other side, is the Second Department decision affirmed in Hoeyman says that the basis of the invalidity must be a procedure of a departure of substance. A departure of substances. And that's the only thing I could find that would justify the unique circumstances found in the court. Hear me out real quick.
Oh, I'm sorry, Judge.
No, you're doing fine. I'm sorry to keep talking, but real quick, just to finish up. But your brief, as I see it, doesn't discuss the basis of the invalidity and as to whether or not the basis is a departure of substance or a departure not of substance, whatever that might be. So I don't see that you've really addressed Hoeyman to make use of it vis-a-vis the basis of invalidity. That's my concern.
Okay, well, I think it's fairly straightforward. In Hoeyman, the Court of Appeals simply said that if a particular legislative act must be passed by the local legislative body and must be ratified by a mandatory referendum, the failure to hold the referendum, it's kind of a procedure, but it's the substance. You can't fail to ratify the act of the local legislature. And if it never happens, the law never takes effect. It's jurisdictionally defective.
Based on the language of the GML, right?
Yes, the statutory requirement, which was...
GML says if you don't do it, it's invalid. We don't have that here in the Constitution,
but
if you made that argument.
But the challenge in Hoeyman was saying, well, it's only procedural and 10 years have gone by. And the Court of Appeals is clarifying there, no. If you have no jurisdiction, if your act is void ab initio, it cannot become effective by the mere passage of time. And this is very similar. If the legislature does not have the power to consider the proposed amendment prior to the receipt of the Attorney General opinion, then when it acted here, an hour after it introduced the proposed resolution, it did not have the power to act. Its act is void ab initio.
Only if that's a departure of substance. And what tells us whether it's a department of substance or a department of just pure, straightforward procedure?
Well, for one, Judge, if you think about it logically, and you all know this, an Article 78 is derived from centuries-old writs that are used against administrative bodies, rarely against the courts, and they are the courts reviewing whether basically an administrative body, sometimes a local legislature, but acting in an administrative capacity, as in, save the Pine Bush, when the issue was whether the local legislative body properly followed SECRA, right? Did it act in an arbitrary or capricious manner? The courts do not review the wisdom of the way the legislature acts. The legislature can pass laws, and they're not reviewable by Article 78.
What do you think of the AG's commitment today that they said that if it had been in Article 78, it would have been heard in the nature of a mandamus to review? Now, what do you think of that?
I don't Respectfully, I don't know what it means. Mandamus, as you know, is used to compel an act, to compel an officer to take an act where there's no discretion for the officer to withhold his action. How would this be reviewed by Article 78? It's not mandamus. You can't review it to say whether it was arbitrary and capricious. It's not a writ of prohibition. Writ of prohibition only lies against judicial or quasi-judicial
Well,
bodies.
the certiorari prohibition and mandamus, they've now tethered their wagon, so to speak, to mandamus to review as opposed to mandamus to compel. Just, I know we're slightly off the issues only because I don't know that you've teed up the whole departure of substance argument in your brief very well. That is the basis of the invalidity, and that's my concern.
Well, I would just go back to saying that, two points, I guess, not to repeat myself, but one, an act of the legislature, a legislative act taken under Article 3 of the Constitution, I don't believe has ever been challenged by Article 78. How can the legislature be reviewed by the courts under the Article 78 provisions? And two, of course it's substantive in the sense that this isn't some sort of, we're not arguing that they forgot to put a piece of paper in a file like a ministerial act. We're arguing that they don't have the jurisdiction or the power to vote until they receive the opinion or the 20 days goes by. So that's why I think it's clearly, this is a declaratory judgment action. Every time that the Court of Appeals has reviewed the meaning of the Constitution, it's done so in the context of a declaratory judgment. I mean, the Saratoga County case, Saratoga Chamber of Commerce case that we cite in our brief, that case turned on whether the governor had acted in an ultra vires manner, just as we're saying here, the legislature acted in an ultra vires manner. And it was brought 6 years after the governor signed that compact and 4 years after the casino that it allowed to open had been operating. And the Court of Appeals allowed it to go forward, did not dismiss it on laches grounds, even though the casino had been operating under what seemed to be a valid, act of the governor for 4 years. So this is really, I think, an unprecedented argument that the legislature could be held to review by the courts under the provisions of Article 78.
We'll take a look at that, counsel. Anything further?
If I could just very briefly on the plain meaning, I don't think that it's in debate that upon receiving means after receiving. And in fact, if you look at the reply brief of appellants, they basically concede that. They say that the Constitution contemplates that the opinion would be received, but it doesn't mandate it. So if the Constitution contemplates that something will happen, how is it that it doesn't mandate it? They dismiss it as, well, it's not a very important provision. Well, is the legislature the judge of what's important? The legislature can just say, well, we don't have to read it. Well, they don't have to read the bills either, but the bills have to be on the desk for 3 days. So you don't get to say, well, it's 2 days, and everybody knows what the bill says. We don't really need this. No. The Constitution sets down these requirements. Again, they concede that the purpose of inserting the Attorney General is to augment, is to foster the deliberative nature, and yet they're taking a position here that they don't need it, it's not important, we can vote an hour later, it doesn't have any meaning. That is not what the intent of the drafters is. You have the quotes from the drafters that it was thought that it would be very helpful to the legislature that then upon the opinion coming back within 20 days, then the legislature, what the drafters intended. Immediate referral, AG has a duty in 20 days to return a written opinion, and upon receiving such opinion, the legislature can proceed to vote. That completes the initial phase of the amendment process. There is no justification for the legislature to say, well, we just did it and we could get it at any time. That means that upon receiving could mean before receiving or at any time. And my final point, not to belabor your time, but failure. Failure to act. Yes, failure to act includes 2 scenarios. The first scenario is the Attorney General never acts. The 20 days goes by, the legislature takes its votes, the resolution is adopted, let's say, and they never get an opinion. That amendment makes clear that's valid. The second scenario is, let's say 22 days goes by and the legislature votes, and on the 24th day, the Attorney General renders an opinion. Now, there could be a question as to whether the late opinion affected the validity. The amendment makes clear it does not. but that is a failure to perform a duty. Their argument is akin to saying, how could the Attorney General fail to act if she never had the materials in hand to act? How can you say someone failed to perform a duty if the time for the performance hasn't come due? That's akin to saying that you have 20 days to answer a complaint, but on the second day, if I don't have your answer, I can say, well, you failed to give it to me. No. I don't think that's not an escape clause to render the structure above a nullity, such that there is a sequential structure above, but in the last sentence added 3 years later, that whole structure goes out the window and it becomes meaningless. That is clearly not the
wrap up,
intention.
counsel.
I thank you very much for your time.
Real quick,
sure.
No, just real quick, on standing, just so I make
Yeah.
sure I have your position. First of all, do you agree that with the AG where they say that you've effectively waived the standing based on the assembly member? And two, if not, which category of standing for legislative standing do you rely on in that? So those two questions, I just want to cover that.
I'll do it in 2 minutes. None may read the majority opinion in Borzowiski v. Bridges without concluding that a citizen or taxpayer has the right to challenge in the courts as unconstitutional acts of the government, the classic means for the effective scrutiny of legislative and executive action. Wien versus Carey.
You understand I'm asking you about the legislature?
And on legislator standing. Legislator standing is a concept that arises when...
Forgive me. And I just, because I know our time is limited here.
My-
One is, do you agree with the AG that you've effectively waived or conceded on that point as to legislative standing? And if not, which category of standing do you rely on vis-a-vis silver? There's three different
Our
ones.
position is that legislator standing is not applicable in this context. It's not a separation of powers challenge.
Thank you, counsel.
Thank you very much.
Recess.